Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and this morning I'm looking at a book which has come to us from Oxford University Press. It's a well-known book, it's a very substantial work. It's known as Bellamy Child, and it's Bellamy and Child, European Law of Competition. And it's now in its 8th edition, and it's been of course edited by David Bailey and Laura Elizabeth John. I do apologise, Laura Elizabeth John. Now, OUP have come up with a brand new edition at a time where we're looking at very substantial changes between the relationship on the continent within the European Union between Britain and the other member states. And Elizabeth wrote the original draft and was the lead writer on this book review, and she came up with the title, What Competition Lawyers Might Have for Brexit. And that's a little joke because it's not breakfast, it's Brexit. Just in case you didn't get the joke, because it is actually something, because it's a heavy book, so we're going to start off with something amusing before you get into the book itself. Let's have a look at it, because it's a very heavy book indeed, in all sorts of ways. It's very, very weighty. It's a red book. There's the front and then there's the spine. There's nothing on the back. Now, the book itself runs to, and the pages are quite thin, it runs to 1,600 pages, and you can see from the index at the back alone, it's very heavy. The back, it's actually by paragraph numbering, the index, so you can find things quite clearly, but it's a very detailed index. And the index starts here on page 1551, and you can see again it's a substantial index, and then we're working backwards. We get to the last chapter, chapter 17. You see there's paragraph numbering and footnoting throughout. Paragraph numbering at the side, that's where you can find the numbers from the index, and very substantial footnoting. If we go to the front, there's the front page, and then after that you've got a very large editorial team, because clearly a very large number of people have been involved in this work. You can see all the names. I can't go through them all. But the two authors, of course, are both barristers. And then Bellamy actually writes a foreword, and he's the named, obviously the original named person. That's dated May 2018. Obviously, he's talking about the way in which the book has now changed. There's a preface to the new 8th edition, and the preface is quite detailed. It explains all the changes that have taken place. And again, the preface, actually May 2018 it was actually written. Then you've got the contents section. You can see how that is structured, and it goes through the articles, very substantial, the relevant competition articles. And then finally, out of 17 chapters, you've got state aids. Now, what you've got in each of the chapters is the name of the individuals who've contributed. And as I say, I can't go through all of them, but there are a lot of people involved. There are some tables of cases throughout, and then after the tables of cases, which there are a large number, you've got treaties and legislation. That runs through again to quite a lot of pages. And then you get, after that, because it's all linked together, you do have a very useful abbreviations section. You see, even now I'm holding this book, and the actual book, we haven't even got to page 1 yet, but the abbreviations are very helpful. You can see how that is structured. Then you get to the book itself, page 1, here we go. So you can see already that you're getting to nearly 2,000 pages with this book in real terms. There's chapter 1. You see it's got a nice little index to the chapter, so you should be able to find things pretty quickly. Once you know which chapter it is and the paragraph numbering, you should then see the paragraph numbering at the side. That is on, as you're looking at it, on the left, and the footnotes down at the bottom. And that's the way it runs through. The footnoting is very extensive throughout, which is to be expected. The paper is lovely, the way it's printed on, which means that the book itself is a lot heavier than some of the other books we have today, where the paper is very thin, but this is a nice quality paper, And it's a good read, but this is not an easy subject. Let's be absolutely clear. I did this module for my bar examinations, and I'm well aware of how little I actually know about the European Union law of competition, even now. It's a very complex area, but I think this book does make a lot of explanations much easier. Now, what does Elizabeth say, and what do I say about this book? Woe, alas, we're leaving the European Union, that is, but lawyers, especially UK lawyers, will continue, well, indefinitely, to require reliable and authoritative works of reference on European law. This one, in other words. Now, I say we're leaving the EU, but we haven't actually just left yet. We'll see what happens. But on the basis we are going, we're still going to have a tremendous direct relationship concerning issues like the substantive law of competition. And this is where Bellamy Child comes in. This book's been published by OUP. It's a long-established text by now, and the brand new 8th edition just come out in 2018. It incorporates a wealth of informed commentary and analysis of the momentous developments within the European Union and competition law that have emerged since the previous edition was published in 2013, the most earth-shaking of which, of course, is the imminence of Brexit. That's Britain's withdrawal from membership of the European Union. And at the time of publication, not to mention the date of this review, question marks at the 11th hour still loom over the UK's exit, which was scheduled for the 29th of March 2019. Well, I'm actually recording this a couple of days afterwards. We wrote the review before the deadline date, but we haven't gone yet. We'll see what happens. The two editors, Bailey and John, that's David Bailey and Laura Elizabeth John, can only observe, quote, that the traditional arrangements and the future relationship, if any, between the UK and the EU are yet to be negotiated. And alas and alack, that is where we are at the moment, as we approach Easter, and we still don't have a decision. Now, therefore, this book is very relevant because whatever happens, whatever transition arrangements we may well have, even if we're in, say, a customs union, this book is going to be extremely valuable for the next few years. And what we've got here, of course, is with the new edition, they reflect the developments that have emerged in the area of law since 2013. And that includes recent and current case law with examples, decisions, appeals and judgments. So therefore it's a very full statement, and this is where the law is at the moment. Additionally, there's a commentary on proposals for further reform of European Union competition law. And we will be affected, whether we like it or not, and those Brexiteers may have to put up with it, but we will be affected by it, so we have to know about it, which has meant, of course, that as the editors explain, all the chapters have been substantially revised and updated for this new edition, and of course they will have to do another one once we know the full horror of the withdrawal, as and when it takes place. I imagine it will take place, but when, we don't know. It's pointed out in the book's introduction that this work of reference concerns itself chiefly with the competition rules of the EU pertaining to the functioning of the internal market itself, which is referred to as including a system ensuring that competition is not distorted. Now, can I just say on that whether we stay in the internal market or not, we don't know. It's quite possible we could have a version of the internal market, so these rules will be directly relevant even then. Now, the book's 17 chapters expand upon this premise over a broad range of topics. They include abuse of a dominant position, a very fundamental concept, of course, of competition law, for example, as well as cooperation in R&D, research and development. I thought especially interesting was chapter 12 on sectoral regimes, with its succinct commentaries on electronic communications, energy, insurance, financial services, postal services, agriculture and transport, just to name some of them. Can I just say that again, that's an area where whatever happens, we need to be up to date with the big changes that are taking place. The sheer diversity of the subject matter under scrutiny here is, of course, in our view, very impressive, and it's a tribute to the book's editors and the 36 expert contributors. The editors, of course, are careful to mention the law stated is to be accurate as at 2017, although further developments have been added, including, to summarise, the example of the Commission's decision to impose a fine of €997 million on Qualcomm for abusing its dominant position by making significant payments to Apple to purchase exclusively Qualcomm chipsets for its iPhone. And of course, these are big sums of money we're talking about. We're not talking of very small sums of money here. We're talking of a very large amount of money. And this is the role, and will be, in my view anyway, the future role which the EU and us, inside or outside, will have to understand and face up to. So Brexit or no Brexit, examples like this only serve, as I say, to illustrate the international, that means the multinational, which business generates, and the implications and consequences thereof, obviously across the board and across the globe, because we are actually in a global community. It's developed quite quickly, and we have to recognise that for competitional purposes. Now, at the same time, it appears to point to an immediate future in which the inevitable legal and administrative interdependence of the European and the United Kingdom will doubtless continue well into the post-Brexit era. And I'm making the assumption that Britain will leave and honour the referendum of 2016. Let me conclude then by saying that all of which means that any or all UK corporate lawyers on either side of the Channel seeking career advancement in competition law will certainly benefit from the clarity and informed comment that abounds in this definitive legal text. And it is the ultimate statement. I haven't seen anything in one volume which covers everything that you need. I wish I'd had it actually to a certain extent when I did the bar module, because I do find it a very interesting area, but things have changed very much in the last 30 years, so I think I can be excused. The date of publication is cited as at the 20th of December 2018. Let's just have one last look at Bellamy Child. Very heavy book, as I say, nice red cover. There's the spine. There's a nice little divider in the middle. I don't know where that's set, so we'll just have a look. There we go. Merger control. Here we go. Chapter 8. See the structure, your paragraph numberings at the side, and a lot of footnoting, a lot of case law, a lot of, in fact, not as many cases, a few just here, but this is mainly memorandums of understanding, and then we get, for instance, you get quite a lot of case law there, which goes on a little bit later. Anyway, thank you very much to everybody who has been involved in the production of this work. I think it's an important work, and one that will need to be updated again at a relatively later date. In the meantime, we have it. OUP are to be congratulated for producing what is a first-class book, and thank you to all. Bye-bye.